Welcome, everyone. Good morning. Good morning. We'll go ahead and get started. It is 11:30. I'm Brandy Gray, Talent Management Professional and 2025 Programs Committee Ambassador. I'm so glad you reserved this time in your day to join us for this relevant discussion around employment law updates for 2025. In an ever-changing employment law landscape, this session will discuss key employment issues that employers are likely to face in 2025 as a new administration takes over the federal government and new state laws emerge. We will explore the new federal laws expected to impact employers in 2025. We'll talk about state and local trends, including expansion of paid leave and paid transparency laws, and we'll identify some issues to watch out for in 2025. If you're like me, you're eager to hear from our speaker. So let's address a few housekeeping items, then dive right in. Our speaker today has prepared a special presentation for you. We welcome each of you to participate by sharing experiences and questions using the chat feature or the Q&A feature. We will have time at the end to address questions, but feel free to ask throughout the presentation. Also, we would love to hear your feedback after the webinar. There will be a short survey provided at the end of the presentation, and we'll use this data to ensure we continue to provide you, our members and guests, with speakers and topics that are relevant and interesting to you. Finally, a follow-up email will be sent to all attendees a few days after the webinar that will contain the CE credit information. Now, I will turn it over to our speaker, Bryance Metheny, partner and chair of Burr Forman's Labor and Employment Practice Group.
All right, let me get my screen shared here and we will get going. Okay, hopefully everybody can see that. Good morning. As Brandy mentioned, I'm Bryance Metheny. I'm excited for the opportunity to talk with everybody this morning. This topic that we're going to be addressing for the next 30, 40 minutes or so, labor and employment in a new presidential administration, is one that unfortunately I'm old enough to have delivered 4 or 5 times now over my career. But I can say that, with all the times I've done it before, it's never been as unpredictable as what it looks like Trump 2.0 is shaping up to be. So I think we have a lot to discuss this morning. For those of you who aren't familiar with me or Burr Forman, my law firm, I'm the chair of our Labor and Employment Practice Group. We're a 400 lawyer, full service Southeastern law firm with one of the largest L&E practices in the Southeast. Our firm began as a labor law firm over 100 years ago, and that history has given us the opportunity to represent some of the largest employers in the country. My home office is Birmingham, but I'm licensed in 5 states, including Tennessee, and I practice all over the United States and handle traditional labor matters, complex and class litigation, and really anything that touches on the employer-employee relationship. So I hope that experience is going to give me some insight into what we can expect from these next 4 years as we watch the labor climate fully flip. I mean, I genuinely believe fully flip from the past 4 years in the Biden administration. So my plan this morning is to do, candidly, a whole lot of speculation and guessing, because the simple truth is that not very many people have a real good sense of what's about to happen with this new administration. Right out of the gate, we can see it's likely to be, what's a nice way to put this, very non-traditional. We often make predictions as lawyers that are perfectly accurate just based on the party that won the election. That's not necessarily the case here. What we have more than anything right now is a populist administration that clearly doesn't feel burdened by traditional party platforms or party norms. For example, the nominee for health secretary has a history as an outspoken abortion rights advocate. That's not exactly what you'd expect from a Republican president-elect. The nominee for intelligence is a Democrat, which is certainly not what you'd expect from a Republican president-elect. But most relevant, I think, to our conversation this morning is the fact that Trump's nominee for labor secretary is the most pro-union Republican in America right now. So nothing is normal, and all bets, to some extent, are off. So what I plan to do is go over some of the more critical kind of big picture changes that we saw under the Biden administration that most directly impacted how employers manage their workforce, and especially you folks, HR directors, in-house counsel, CEOs for those employers. And then we're going to attempt to predict what's going to be different about those efforts for the next 4 years. This presentation is not going to be your typical take notes and let's go edit our handbooks kind of conversation. We're really not going to get most labor lawyers like me predict any new foundational shifting laws. Nothing that's going to change in a big picture sense how we operate our workforces. So for the next 30 minutes or so, we're going to think about ways our strategies and our tactics for workforce management will change based on the culture that's going to be created by the people who are interpreting the existing laws. So to start, as I've already hinted, this is not going to be 4 more years like Trump's first 4. That really seems apparent already. We just can't really use 2016 to 2020 as any sort of cheat sheet. The Labor Secretary appointment illustrates 2 pretty important distinctions that I see in this Trump administration. The first is that he's more prepared to put his personal stamp on the way this administration governs. In 2017, Donald Trump was not prepared to be president in the sense that, like everyone else, I think he was probably pretty surprised that he won. And so his initial nominees to the most important roles in almost every way were very establishment. They were very Republican establishment. It indicated that most of the recommendations that he received and those that he accepted were from regular Republicans who wanted to govern as conservatives. In contrast, yesterday, in fact, he issued almost 200 executive orders. Most of those were to stake a claim about what's important to him specifically. Now, those executive orders don't actually have the force of law in many instances, but they do tell us a lot about how different it's going to be this time and what the actual agenda will be. Take, for example, the difference between his appointment of Peter Robb as general counsel to the National Labor Relations Board back in 2017 and compare that to his labor secretary nominee for his new administration. Peter Robb was an establishment, old school lawyer from a big law firm who represented employers, and he had a reputation as a union buster. Most people believed that he would, and he in fact did, take the board in a very pro-business direction that sought to fundamentally change the way the National Labor Relations Act is interpreted and administered. He rolled back advances that unions had made during the Obama administration and created an environment that overturned precedent that had made it harder for employers to respond to unions during campaigns. But Trump's nominated labor secretary, Lori Chavez-Derrimer, is a very vocal union supporter, even though she's a Republican. She's almost certain to be confirmed in short order. So she is, almost certain to be our new labor secretary. And as you just heard, she's a Republican who supported President Biden's PRO Act, which was the most union-friendly piece of legislation any president's ever genuinely attempted to pass. She's been sympathetic to legislation that would raise the national minimum wage, increase the minimum salary threshold. She almost certainly will not view the Labor Department as a mechanism to increase employer control over employees. So the question is, why did Trump do this? And that answer informs our conversation this morning. This administration is clearly making its own calls on these appointments and agendas, and it's not really relying on the party establishment to guide it this time. Donald Trump's never been a traditional Republican with party platform principles in the first place. So we can't really just cut and paste from prior Republican administration talking points, or even, as I mentioned, from his own past actions to predict the direction that this is all going to go. That said, we know he's also not an extreme liberal on employment-related matters either. President Biden had proclaimed himself to be the most pro-labor president in American history. And he certainly tried to be. So whatever Trump 2.0 will be, it won't be that. So we know that many of the important and relevant Biden administration goals won't survive. We also know that Trump's first term established a conservative Supreme Court majority, which may in fact have more influence than any other factor on these next 4 years. So while I want everyone to understand that everything I say could prove wrong, because we've entered the golden age of who the hell knows, I'm actually pretty confident about the things that I'll be predicting this morning. So let's start with some context. Some of this is going to be clearer in the next few weeks, but some of it won't. As you just heard, the board appointments, the cases decided during the Biden administration, some of those will take some time to change. And we'll talk a little bit more about that in a few minutes, but sort of at the outset, just to kind of level set where we are, it's going to be hard to get anything done. As most of you already know, the margins are quite slim. Trump struggled to get much of anything done early in his administration, 2017 and 2018, and the margins in both houses of Congress were actually wider then than they are now. The simple fact is that when it comes to the task of governing, it's much easier to align against a president than it is to hold a party together when you're trying to get something passed. So, if we're trying to get an action done, it's harder to get those people to coalesce around the idea to make a change than it is for the opposing party to simply align and say, no, we don't want that. So that's why Trump has decided to do almost everything initially via executive order rather than proposed legislation, because it's hard to get a piece of significant legislation passed, even in the best of times. These are not that for the Republican Party because these margins are so tight and the cohesion even within the party is not as strong, since frankly, the party platform matters a great deal to some, not at all to others. As I just mentioned, the Supreme Court is already very conservative, and it's likely the preferred path for many issues that matter to President Trump. There's also a reasonable chance that this conservative majority could expand. If we look at some of the ages of these current Supreme Court justices and recognize the impact that the Supreme Court has in particular on employment law. And that's because the job of interpreting all of these laws that we deal with every day, the ADA, the FMLA, the Fair Labor Standards Act, the National Labor Relations Act, everything that impacts, how we manage our workforce. Ultimately, those are federal laws that are interpreted by the federal courts, which means that the United States Supreme Court has a really important role in that interpretation. So the Supreme Court justices matter a lot in this world. Clarence Thomas and Samuel Alito are, in their mid-70s. We can anticipate that one or both of those may retire during this term, which means that President Trump could replace those with much younger, as he's clearly indicated as his preference, with Amy Coney Barrett, Brett Kavanaugh, Neil Gorsuch, who are relatively young for Supreme Court justices. The expectation is that they could be replaced by conservative justices who will have a longer lifespan on the court than Alito and Thomas currently do. And then also we have Sonia Sotomayor, who is one of the few remaining liberal justices on the court, who is 70. So there's an opportunity there potentially for the conservative majority to either be extended, its lifespan to be extended, or to be increased, depending on what happens with the ages and the retirement plans of some of these judges. Some other key appointments that matter besides those that we've already discussed, things that matter to us in this employment law world. I already mentioned Lori Chavez-Derrimer. We're going to be talking a little bit more about some of the labor issues as we proceed. But beyond that, one of the most critical appointments is going to be general counsel to the National Labor Relations Board. And that has yet to be announced. We anticipate that the termination of the existing general counsel, Jennifer Abruzzo, will take place in short order. It may have already been done and I just missed it. There is no possibility that President Trump is going to extend the term of Jennifer Abruzzo. The role that the general counsel has on setting culture, climate, policy agenda, enforcement activities at the board can't really be overstated. It's an important function. We don't yet know who that's going to be, but it will be someone that will change in significant ways the way that the board approaches labor issues. Andrea Lucas is expected to be named the chair of the Equal Employment Opportunity Commission, the EEOC. It seems a virtual certainty. It hasn't been formally announced or officially announced, but she's the current and only Republican commissioner. We're going to talk a little bit more about her views and the influence that she might have on the EEOC in just a second. Also unannounced to this point is the chair of OSHA, who is going to run OSHA, who is going to set the agenda for OSHA and how it's going to deal with the next 4 years. Again, this is an area where we really haven't heard President Trump say much about workplace safety or regulations in that sphere. So we don't anticipate significant change, and we don't anticipate someone who is going to have, kind of a foundational shifting approach to it. But we do know that, that is still unpredictable. We still don't know who that person's going to be. And, it's an important role. We know that it's an important role. And then finally, at least for our purposes of discussion this morning, the chair of the Federal Trade Commission, the FTC, is proposed to be Andrew Ferguson. The FTC was very active under the Biden administration, and we're going to talk about some of the ways that they were active and the ways that their agenda impacted workforces on a day-to-day basis. Ferguson is what I would describe as a very traditional Republican, very establishment. He's the former counsel to Mitch McConnell, who I think a lot of people would agree that Mitch McConnell is the Republican establishment. He is sort of the personification of what establishment means for Republicans. And so given that he was the counsel to Mitch McConnell, we can anticipate a much more traditional business-friendly approach to the FTC, which will be a tremendous departure from what we've seen for the last 4 years. Some of the policy changes that we anticipate, much more directly impacting our day-to-day, starting with the Department of Labor. And so I've already mentioned multiple times, just what was candidly a little bit of a shocking development with the secretary that was nominated to run the Department of Labor, a one-term Republican representative from Oregon. She's only served 1 term in Congress. What's more significant, as I've already mentioned, is that she actually co-sponsored the PRO Act and other pro-union legislation that was purportedly bipartisan during the past 4 years. But, we're talking about a Republican who is supported by labor unions, which is just a thing you don't see very often. But labor unions like the Teamsters, her father was a Teamster leader in Oregon. And so, a long history, a long relationship with organized labor. And so, her impact on the Department of Labor is going to be incredibly interesting because it goes beyond just the union context, whether or not employees have the extent to which employees have the freedom to organize. The Department of Labor impacts, as we all know, lots of different areas that can affect our day-to-day. One of the ones I wanted to mention in particular, because, this has been for the past 16 years, basically a pinball effect, is the independent contractor standard. Going all the way back to when President Obama was elected, one of his first acts was to narrow the test for independent to make it more difficult for employers to classify workers as independent contractors. And there are a lot of reasons that we, as employers sometimes want to do that. President Trump in 2017, when his administration took over, expanded it again, back to where it was under the Bush administration. Then President Biden came in and put his own stamp on it. So President Biden's DOL used an economic realities test with 6 factors that all were deemed equal. The past administration of President Trump, it was really more about control and profit opportunity. President Biden was much more about really the sort of fundamental, does the employer even have the ability to control the manner in which the worker performs the tasks that he or she's been assigned? Under President Biden, almost any worker on site had to be treated as an employee. It was too risky to treat them as an independent contractor. So, just kind of right at the outset, we expect a return to the Trump era core factors test, or even a new standard that makes it easier to classify workers as contractors. And, it's going to focus on, does the worker have substantial control over the performance of the work? Substantial control. And note the difference there between substantial control. In other words, my supervisor tells them what to do all day long, versus the ability, even if it's indirect, even if it's simply reserved but not exercised, ability to have some control over that worker. And that's a pretty significant departure from how the Biden administration has addressed it. Does the worker have the opportunity for profit or loss based on their skill? In other words, is the person that I am classifying as an independent contractor, could they make more money if they do the job faster or better, or hit some metric that is pre-established in the contract versus just a wage, right? They're gonna work for me for 8 hours, they're gonna make $80, versus if they work for me for 8 hours but produce more, can they make $160, on the job that they've been assigned to do? Or, on the flip side, am I only going to have to pay them 40 because they didn't get as much work done? The opportunity for profit or loss will be a much more significant factor. And then, of course, the amount of skill, whether they're permanent versus temporary, whether it's part of a production model, all of those things are going to be factors. What I tell people, look, if you've got workers that you're classifying as independent contractor, it's something that you need to consistently audit, because there's a lot of risk there. Under any of these tests, there's a lot of risk in classifying someone as an independent contractor. So pay attention to whether or not we have the day-to-day control over that worker. If you do, if you've hired a temporary employee and that temporary employee is working side by side with the rest of your workforce, you're a joint employer. Okay, they're not an independent contractor. And so we want to just kind of be practical about some of these issues. But what we do know is that there is a better opportunity under the Trump administration, or there will likely be, to classify workers as independent contractors. Another issue that we've been dealing with for the last year or so, probably a lot of you have been giving consideration to the increase in the salary exemption threshold. If it feels a little bit like deja vu, that's because it is. This exact same scenario played out when President Trump took over for President Obama in the 2016-17 range. Obama's administration had just raised the salary exemption threshold. A Texas federal district court had struck down the increases. And the Trump administration came in and elected not to appeal the injunction by the Texas federal district court, let it lapse. But then the Trump administration put its own stamp on the minimum salary threshold and increased it a little bit, not a lot, but a little bit. And so it went from about $26,000 to about $35,000, where it had originally been proposed to go up almost to $60,000 under the Obama administration. So will we see that again? I think it's possible. We've already mentioned that the labor secretary, who will have a lot of control over this particular issue, is very employee friendly, and there's a possibility that she will find some middle ground there. So while we've been able to put this minimum salary exemption threshold increase on pause, we may have to pay attention to it again soon when the current labor secretary begins to start taking some affirmative action once she's taken over. So pay attention to that. Right now, we can say whatever efforts that you made to increase the salary of employees that you were treating as exempt, those are paused. But pay attention, because it could come back on our radar sooner rather than later. Both parties campaigned on a couple of unique ideas, things that, frankly, haven't come up in recent administrations and recent campaigns, and that is no tax on tips and no tax on overtime. We have already seen that Ted Cruz has introduced legislation to codify no taxes on tips. Okay, it will likely be bipartisan. There will probably be legislation that eliminates the tax on tipped earnings. So, the employees can be taxed for their earnings that are not, the tip share of the wages, but for, portions of their compensation that are tipped, there will probably be some legislation that addresses that. It is going to be complicated. Okay. It is already hard enough to manage tipped workers, to account for the tip credit and to pay people differently depending on some of the functions that they have in your workplace. If you have tipped workers, it's going to get more complicated when there's a federal law that makes, that establishes a difference between the wages that are paid that are hourly versus the wages that are paid that are attributable to tips. Stay tuned, because that's coming. We know that's coming, and it's something that we're going to have to account for in our payroll. The second part of that is no tax on overtime. And this has not yet, legislation has not yet been drafted to address this, but some states already have it. For example, the state that I'm standing in right now, Alabama, already has a law that has eliminated tax on overtime. And I can tell you that a lot of employers in the state of Alabama have struggled with the implementation of that legislation. Whether they agree with it or not, trying to account for it, to determine who is eligible for it. For example, I've fielded a number of calls. What about salaried non-exempt? What about salaried exempt? What if we decide to pay exempt employees overtime, even though they're not entitled to it under federal law, but as an incentive, as some sort of mechanism to make it more attractive to them to work extra hours? Is that covered? All of these issues, hopefully will be addressed in any federal legislation that emerges. But we do know that it's going to be more complicated to administer a payroll that distinguishes between wages that aren't overtime and wages that are overtime. But it's likely to happen because it's an easy bipartisan win. Right now, Kamala Harris campaigned on it. So there is a likely, sense in Washington that everybody likes this, so let's do it. But if I'm an employer, if I'm an HR professional who has to manage this issue, I've already mentioned the concern about sort of the complications for payroll, things like that. But let's also think about the impact that it's going to have about incentives. Every organized labor campaign, union campaign that I've been involved in has revolved around, at least in some part, there has been an issue of excessive overtime, unscheduled overtime, especially in manufacturing environments. How much overtime we're scheduling our workers for, it can create morale issues. It can create all kinds of problems. Well, clearly, I think we can sort of predict what's going to happen if there is no tax on overtime. The idea, in the states that have passed these laws is that there's no tax to the employee, and the employee's wages over 40 are not taxed to the employer either. So there will be an incentive to work more overtime and less staffing up to maintain a consistent workflow at about 40 hours a week. So work-life balance is going to become a problem, and it could potentially trigger, I predict, some union campaigns. Some employees who have decided, tax or no tax, I don't want to work 70 hours a week, and my employer is requiring it, and I need to go get a third party to come get involved in this relationship to represent me, to challenge some of these decisions that the employer's making. So again, kind of just be aware as these laws begin to trickle out, what's the impact going to be on my organization? Because it's not as simple as, cool, nobody likes taxes. That's a win for everybody. It obviously will come with some unintended consequences that we need to be prepared for. I mentioned OSHA. Again, we don't expect upheaval with OSHA, with safety laws, because frankly, the regulations are so complex, nobody really even wants to dive into all that stuff. But under the previous Trump administration, we saw a decreased number of investigators and investigations. Expect that again, okay? One of the things that we can anticipate is that the ramp up of investigators, of audits, of unscheduled, unplanned visits to work sites is going to decrease. And that's especially true if this whole concept of Department of Governmental Efficiency, the Elon Musk sort of alignment, if that becomes more of a factor in the Trump administration, having too many federal employees is going to be something that they'll push back against. Well, usually the reason we see increases in the number of federal employees is when presidents like Biden and Trump, focusing on things like audits and investigations and, with the Department of Labor, with OSHA, hire more investigators. We saw hundreds of investigators hired during the Biden administration to ramp up OSHA compliance. So, we would anticipate that that would decrease again under the new Trump administration, and that there will be more of an emphasis on compliance assistance, less on press releases. Okay, so, instead of penalties, fines, shaming style press releases, we're going to see more, attempts to work together to comply. We'll also likely see some recent regs that have been passed, reversed, ended. The walk around rule, where an employee can request that a representative, maybe from a union, is permitted to walk with the investigator as they conduct their investigation to point out things that they believe are unsafe or that violate an OSHA rule. That will likely be rescinded. Electronic record keeping, the idea that OSHA can audit our electronic records and require us to keep them so that it's more easily accessible, probably will be rescinded. The heat safety proposed rule has been very controversial, simply because it, for most employers, it seemed to dictate beyond OSHA's jurisdictional authority. We would anticipate that would be rescinded. And, again, like I mentioned, just less of a shame approach through press releases and much more working with employers, lowering the thresholds for things like severe violator. I can tell you that we've seen an increase as employment lawyers in severe violator findings by OSHA, willful repeat citations to support heightened penalties, larger and larger penalties that have been imposed based on things like severe violator, willful repeat citations. So, we would anticipate that there'll be some relief there for employers, that we won't have to worry quite as much about getting hit with willful violations under this new administration, and that we will have, there'll be less likelihood that we're going to see surprise audits or, an excessive number of audits and investigations under this administration. We talked about the EEOC just very briefly when I mentioned Andrea Lucas earlier. She's likely to become the next EEOC chairwoman. One of the things that we know about her, very conservative, okay, often critiques the EEOC for the way that it supports, encourages, and even uses internally its DEI program. So there's going to be much, much less emphasis on diversity, equity, and inclusion programs under the EEOC if Andrea Lucas is in charge. We know that for sure. She has criticized the EEOC's, what she believes is an expansive interpretation of the new Pregnant Workers Fairness Act. And that's interesting because the Pregnant Workers Fairness Act is one of the few pieces of legislation that was actually passed and has a direct impact on how we manage our workforce during the Biden administration. Because what that act really does is it makes pregnancy fundamentally like a disability under the Americans with Disabilities Act and requires accommodation in the same way. And in some ways goes beyond the ADA. And certainly in the EEOC's interpretation, it goes well beyond what our obligations are under the Americans with Disabilities Act. So, that is an area where we would anticipate the EEOC guidelines and that EEOC enforcement will change based on Andrea Lucas's guidance of the commission. We also know that Project 2025 has, become a very kind of fundamental platform-based expectation for what we will see with things like the EEOC under Andrea Lucas. And, we already talked about the narrow scope of the Pregnant Worker Fairness Act. Enforcing Title VII to actually prohibit DEI trainings. things like, promoting critical race theory. So, the EEOC is much more likely to find that we're using our DEIs to discriminate than what we have seen, which would have been the reverse under the Biden administration, not utilizing some of these tools to ensure that we have, a representative workforce. Eliminating the EEO1 data collection, that's something that has been controversial, requiring employers to report on certain breakdowns of their workforce, which, a lot of people just don't want the EEOC to have that information. So, we anticipate that the Biden administration, the Trump administration will likely pull away from that data collection. And then, of course, the thing that ends up in our discourse a lot, sexual orientation, gender identity, transgender status, will it or won't it be considered, prohibited sex discrimination? This is interesting because there's really not a whole lot that President Trump or the EEOC can do to affect the direction that this is going to go, because the Supreme Court is going to decide this issue. Is there a constitutional right to be free from discrimination on the basis of some of these protected characteristics? Is probably something that the Supreme Court is going to have to weigh in on and determine. And of course, as we know, as I've already talked about, the Supreme Court is more conservative than it's been in generations. And so we can kind of anticipate some of the direction that it will take. The National Labor Relations Board I've talked about briefly, but I really want to emphasize this because for a lot of us, we think National Labor Relations Board that deals with unions, I don't have to worry about that if I don't have a union. And that's not necessarily true. We certainly do if we have a union, or if we anticipate that we could have organizing activity at our workplace, or or concerned about having that type of activity at our workplace. This one is one that frankly, I'm just really curious myself to see how it's going to play out, because we have a lot of competing interests here that are around President Trump advising him. We have Elon Musk, who has filed lawsuits that have asserted that the National Labor Relations Board is unconstitutional, that the manner in which it is constituted is unlawful, and has sought injunctions to prevent the board from proceeding on unfair labor practice charges against his businesses. And we contrast that sort of mindset with the labor secretary nominee, who I've already mentioned has supported the PRO Act. And the PRO Act was aggressive in the ways that it was going to make the opportunity to organize easier for workers. So those are directly conflicting interests that we're going to be seeing kind of play out in this new administration. And it's going to be fascinating. The current NLRB, we have 2 Democratic appointees and 1 Republican who still have terms left to fill. Okay, we have 2 vacancies, and President Trump is going to move quickly to create a 3-2 Republican majority. Some people thought that Chairwoman McFerrin would be reappointed at the end of 2024. That would give her a longer span before her term expired. That would make it a longer runway to flip the current board, which is Democrat controlled. So obviously, some of the decisions that the board has made have been much more employee union friendly than a Republican majority might have concluded. So it's going to happen faster, is the message, than we would have anticipated with some prior administrations. One of the things that we know, almost to a certainty, is that the current general counsel, Jennifer Abruzzo, will be removed. Again, as I said, may have already happened and we just don't know about it yet, but even Jennifer Abruzzo, one of my partners, heard her speak last month, and she doesn't expect to last much longer than a day after President Trump is in office. So we know that we'll have a new general counsel. And the reason that that's important is because the general counsel really controls a lot of the enforcement activities of the board, the kinds of claims that they pursue, the complaints that are issued against employers. So we know that, and somebody just commented, President Trump appointed Marvin Kaplan as the NLRB chairman. That was, one of the things that was predicted. I could have seen Marvin Kaplan's, obviously staying on as commissioner, but staying in that role with the new chairman. But that is exactly in line with what we're predicting. So we expect a Republican majority pretty soon. And it's important because it's going to impact some of the decisions that were issued during the Biden era in pretty immediate ways. And historically, we've seen it take a good bit of time because two things have to happen for a decision that was made by the board to be overturned by a subsequent constitution of the board. One of the things is that the majority has to flip. So, there has to be a time period that passes so that the president can appoint his own nominees to flip the, conservative versus liberal makeup of the board. That's going to happen more quickly this time than it has in the past, as I've just discussed. The other thing is the right kind of case has to get to the board to give it the opportunity to reverse, precedent. You see on the screen here just some of the things that occurred, some of the Biden era decisions that are likely to be overturned. CMEX is one of the most important. The CMEX case permitted the board to issue a bargaining order if an unfair labor practice occurred during what's called the critical period. What that means is, and especially in my neck of the woods where we've had the Amazon vote down here that made national news, that has happened, well, 2 times, and it's going to happen a 3rd time. CMEX would permit the board to say, we're not going to run another election. We're going to order you to recognize this union and to bargain with it. And that's going farther than any board has ever gone before with the remedies that are available for ordinary unfair labor practice charges. So that's something that we would anticipate will likely be overturned as the board flips. Restricting employer speech about the impact of unionization, that the way that it impacts the management-employee relationship. So recently in Siren Retail, the board, probably kind of as a last act, knowing that, this board was going to flip soon, said that employers are not permitted to say things like, your relationship with your supervisor will be more challenging. You won't be able to directly talk to your supervisor about the terms of your employment if you have a union. And, lots of employers say these things to illustrate to employees the way that that the employee relationship will change if they get a union involved. So the Siren Retail case said that that was unlawful, that it violated the National Labor Relations Act because it chilled employee rights. That's one that we almost certainly think will be overturned because Siren Retail overturned itself years and years and years of precedent that permitted those kinds of conversations with employees. The Amazon case banned captive audience meetings. Well, again, these are the sorts of things that employers have been doing for generations. The ability to call employees into a meeting to deliver to them their view on, whatever union activity is going on. And this board said those were unlawful. Again, anticipate that will be reversed. Stericycle, I don't know how many of you, and this is in particular one that if you have absolutely nothing at all to do with unions, you don't have a union, you don't anticipate you're ever going to have a union, it could still impact the way that you manage your workforce because Stericycle involved workplace rules, workplace policies that can, could be violated with respect to employees that don't belong to a union, because it could be interpreted to limit their right if the policy was interpreted to limit their right to engage in some sort of protected concerted activity. Whether, what's a good example of that, I guess, is telling employees that they can't discuss their compensation with each other. Lots of employers have had those rules for a long, long time. And this board, Stericycle in particular, would deem that to be unlawful because it limits employees' rights to engage in protected concerted activity. We did a lot of handbook reviews after Stericycle came out. We revised a lot of handbook policies and procedures. Frankly, I think for the better, because even if Stericycle is reversed, a lot of those policies and procedures needed to be much more buttoned up to ensure that they weren't even potentially going to run afoul of an employee's Section 7 rights. But, again, that's one that we think will be reversed. And then, we've talked about the independent contractor standard, the board's decision that used a new standard to make it easier to classify workers. What it did was adopted the standard that was proposed by the Biden administration. Almost certainly this will go back to the standard that existed before. And I mentioned, this is one that's challenging for me as an employment lawyer who, advises management. If it's a close call, we don't want to think that this gives us the freedom to just call everybody an independent contractor, because it's just too risky and it's too hard to do. So even though this one is likely to revert to the standard that existed pre-Biden, we still want to be careful with that. General counsel memos, I talked about how Jennifer Abruzzo has an outsized influence on the agenda of the board. And, some of the things that are listed here are just items where she has issued a memo, interpreted the law the way that she believed it should be interpreted, and directed all of the board agents and board attorneys and field agents to take certain action based on her interpretation, and then attempting to persuade administrative law judges that that should be the law of the land. So, all of these memos will be rescinded. As soon as we have a new general counsel, we can anticipate that these memos will be rescinded. There may be some that come back from a new general counsel, depending on what that general counsel, what their agenda is, that are similar to some extent. But we can anticipate some of the more aggressive ones will be gone forever and could change the way that the board approaches certain issues. In fact, I have personally an existing unfair labor practice charge that I'm defending. My expectation is that it's going to go away once we have a new general counsel who rescinds some of the memos that are going to be it's going to impact the way that they prosecute some of these claims. So we'll have to take a look at that. I can tell you all, when you see who the new general counsel is, look at that, think about it. Is that going to have an impact on the way that I foresee the management of my workplace over the next 12 to 24 months? Again, we talked about some of the Project 2025 proposals and the influence that they might have on this administration. One of the things on this list that I think is pretty important is worker management employee involvement organizations. Project 2025 proposal is a little bit more like the European Works Council model, which is much more collaborative rather than adversarial, which is the relationship that most unions and management have, frankly, because the law is set up that way. And so, that's one of the things that's proposed, and we could see a move towards that under this administration. Eliminating card check recognition, the ability of an employer to agree with the union to just, recognize it based on card checks without the secret ballot. A lot of employers believe that opportunity should be eliminated because it prevents employees from having the right to vote on whether they want a union or not. And then eliminating the contract bar, decertification within the first 3 years is an important issue because it limits the ability of employees who don't believe this is working to get out of it if they don't like it. And then finally, we talked about the FTC for a second. And, for a lot of us on this call, if you have any sort of restrictive covenants in your agreements with your employees or within your policies and procedures, non-competes, non-solicits, confidentiality agreements, all of those things have been impacted by the existing Federal Trade Commission. And I think this is the area where I am most interested to see how the new administration treats the FTC. Because you see down there towards the bottom of the slide, one of the things that is unusual is that, Vice President Vance, J.D. Vance, said back in 2024 that he looked at Lena Khan, the existing FTC chair, as one of the few people in the Biden administration who I think is doing a pretty good job. Now, that's rare praise coming from a relatively conservative Republican of the Democratic appointed FTC chair, who had been very aggressive in issuing regulations that essentially banned non-competes. So what does that mean? To what extent does J.D. Vance's opinion influence how the administration is going to proceed with the FTC moving forward? We know that those bans were enjoined by a federal court, but they're still out there. The regs are still out there. Will the Trump administration, will his pick for the FTC job, Andrew Ferguson, will he abandon any appeal of that injunction? Will he issue different rules? Will he endorse the Biden FTC's approach to non-competes? That seems incredibly unlikely, but we also know that President Trump has aggressively stated that he is going to stand up to the big tech companies, that he is going to, even his pick, Ferguson, announced he would end big tech's vendetta against competition and free speech. Okay. What does that mean? I mean, that sounds a lot like I don't like non-compete agreements. And so, do these competing interests, again, sort of filter down to where they impact ordinary employers like us, who are probably not big tech. We're just out here trying to make sure that our trade secrets are protected, that our confidential information isn't exposed. So that's a thing that we need to pay attention to, the way that the FTC's rules evolve over these next 4 years. The ones that Biden administration enacted, and also those that existed before that could have been used to address some of these issues if the FTC had that administrative approach. All of these things, I think, are going to impact most employers. And there's some of you out there who don't use non-competes, that don't have real trade secrets that impact your product or how you go about doing business. But a lot of us do. A lot of us want to protect that information, and we don't want someone that we trained up and taught how to do a unique, inventive skill can take it to a competitor and immediately begin competing with us. So we'll see how that goes. This is one, though, that I think everyone should keep an eye on. That's all I have for today. Obviously, there is a lot more that could happen, as this administration develops. But in the 40 or so minutes that I had available, I picked what I thought was probably the most relevant and would give you the best sense as to where we're headed. Keep an eye on it. Pay attention. If you have any questions, feel free to shout at me, and I'm happy to help try to answer those. But in the meantime, thanks. Brandy, are there any questions that I need to answer right now?
No, actually, I'll go ahead and share my screen.
Okay.
Just so we can have the announcements rolling while I wrap up. Thank you so much, Bryance.
Absolutely. Happy to be
Thank
here
you for this incredibly rich and informative conversation. For our attendees, if you're like me, I'm leaving with more knowledge, and I feel more prepared. I feel better prepared for the future. I'm gonna go ahead and share my screen. Can you release control, Bryance? Oh, there we go. Thank you. All right. I'll just pull this up while we're finishing up. Thank you all for your time. We'd love to see you at our upcoming chapter meeting on February 13th at 7:30. It's at the Tennessee Society of CPAs on Powell Place in Brentwood. Our speaker for that event will be discussing responsible allyship, building inclusive workplaces. Again, thank you all for your time today. Be on the lookout for the email regarding your CE credit in the next few days, and the email containing the short feedback survey. We look forward to seeing you all at another MT Sherm event in the future. Thank you so much, Bryance.